Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we do a little bit of analysis as it relates to the ongoing Nic Rekeita stream, as more of my fellow commentary out there have inserted their opinions on the subject, and for the most part, I find their legal analysis to be broadly correct, which you would expect. We're hitting basically the same points. Some emphasis is a little different than other emphasis, but basically the legal analysis that I've seen generally tracks with my own, which is always validating. Robert Barnes recently provided his opinion. Now, Robert Barnes, in my view, has a bit of a tendency for expressing views that are not in keeping with the current state of the law. But he doesn't make this distinguishment. He expresses his view as to what he thinks the law should be. And his reasons for why he thinks those things are not completely invalid. He has reasons for believing that certain Supreme Court decisions are wrong, or certain precedent is wrong, or certain things should be interpreted in a different way. When it comes to how things should be understood, how they should be understood, there's obviously room for potential disagreement. And if that was what he was saying, I wouldn't be as mad, or I wouldn't be as disappointed, or I wouldn't be as frustrated, because he doesn't make the point of separating it. He doesn't make the point of saying, well, this is the way I wish it would be. He just expresses everything with an absolute certainty, an absolute unresolved clarity, with no mitigating factor, even if the case law does not reflect that. And so I think, therefore, gives people a bad review of the current state of the law. Now, that might be because he, is a practicing advocate, and so he's used to advocating for things. So he might be a fantastic advocate. He might be a perfectly wonderful person to be a lawyer, in your corner. He might be a fantastic person in that role. But, as a teacher about the current state of the law, to help you understand the law, I find his teachings to be misleading at times at best. So we are going to watch this discussion between Robert Barnes and Canadian lawyer Viva Frei, and we're going to discuss this, and we'll go from there. So, yeah.
Battle.
Happy belated birthday.
Oh yes, that's right. I'm 40. I forgot to mention it.
Happy birthday, Viva.
Thursday. I'm 45 years old. The year of the Trump.
Well, any particular gifts or cake or celebrations?
I'm a simple man, Robert. We got steak. We got meat at Easy Meats on Glades, and we had a barbecue. I did the exact same thing on my birthday that I do every day. Did a stream. Got me and another gift, which was fantastic.
Like Amos Miller. So get your products now.
It's a very sad situation, and someone said to me, "Well, you didn't show this much." Well, I didn't reply to it. I have to stop replying to trolls. They said you didn't show this much sympathy and empathy when it was Hunter Biden. I was like, if you don't understand the difference between all of this, then I can't explain it by way of a comment in Twitter. But so the bottom line is Nick and his wife and a third person who I don't know who she is, but content-wise, but an internet personality, were arrested on, they got charged with 3 charges. One was felony possession of controlled substance over a certain amount, 25 grams. You'll explain the importance of that. The 2 were gross misdemeanors. One was possession of firearms in the presence of a controlled substance, and the other was child neglect, I believe. Mm-hmm. From what I understand, and these are public documents, so I don't think I'm saying.
Although I think, as I pointed out before, it's worth noting that at least as it goes so far as Nick's charge, although it's technically labeled as child neglect, it doesn't fall into the category of how I would typically think of that term. So perhaps you and I think about that differently. But when I hear child neglect, what I hear is they were beating the child. The child was malnourished. The child wasn't being clothed properly. The child was ill, severely ill, and not being taken to the doctor. Those kinds of things is what I think of when I hear child neglect. But that isn't what this is. The charge against Nick is merely that children were present at a place in which drugs were also present, which Minnesota technically considers child neglect. They label it that way, but it's not the same to me. So, the label's not the thing, and I think that's worthy of noting. That is at least the charge that's made. So, there you go.
anything that's not public. Apparently there was not a wellness check, I don't know what it is, a mandated monitor who said that they were concerned for the kids being neglected, and then police showed up. This is all in public court documents. They wouldn't open the door, they battered the door down, and they found a bunch of stuff when they came there for that reason from the warrant. Take it from there, because I don't know what more I can add to the situation.
There are substantial constitutional questions about...
Spoiler alert, for the most part, there are not. Also, as was pointed out by Legal Mindset on this topic, or actually strictly speaking pointed out by Steve Gosney, talking to Legal Mindset on his channel, the presumptiveness of law is the presumption is that the statutes are valid. The presumptions are validity. And if you're making constitutional arguments to some degree, you are, in the wrong place. You should be making substantive arguments first. Constitutional arguments, for the most part, are because you have nothing left, and you have nothing left to do. Because, for every possible reason, courts prefer to try to resolve things under statute if they can, rather than constitutional arguments. So, yeah, it's not, it's not great, but okay.
About everything connected to the Rekeita case. So there's been a lot of focus in LawTube on the substantive charges and those that want to make sure that Nic's health is in good state, and that's understandable. But I think LawTube should start to focus on the constitutional issues of what's taking place here. You have a high-profile...
Someone in chat says, dude, you have no idea what the neglect charge was based on. I didn't say I knew it was based on. I said what the charge was. I didn't say it was based on. I said I knew what the charge was. The charge is that children were present at a place in which drugs are present. That is the charge. You can go read it for yourself. I didn't indicate what I thought the basis for it was. I just said that was the charge. And that I don't think that that's what I would typically describe as child neglect. The reason I'm making this point, by the way, is because, once again, it falls in this category of people not listening to what I said and people misunderstanding what I said. I was very clear on what I said. Please listen more carefully. It will be helpful. Thank you.
File critic of the local court system, of the local prosecutors, of the local police.
And Wiggins in chat again. Wiggins in chat says that's not Kayla's charge. Did I say it was Kayla's charge? I did not. I said that was Nic's charge. I said as it relates to Nic. I said as it relates to Nic's charge. At any point in this discussion, did I say anything with respect to Kayla? No. So why are you saying things I didn't say? Just listen to what I say. You'll be better off.
Suddenly being subject to an extraordinary search warrant raid and questionable charges that raise questions under the First Amendment, the Second Amendment, the Fourth Amendment, the Fifth Amendment, and even the Sixth Amendment to the U.S. Constitution. Within 2 days of this case, there are major constitutional questions about the conduct of the government. And that to date has not been talked about at great length. So the First Amendment question is, you look at the underlying facts, and I expected to find something different in the probable cause affidavit supporting detention than what I found. According to the only allegation, there's a lot of false statements being made out there. I love the quartering, but he's been taken in by some of these false statements and false claims. Just go to what is actually alleged in the probable cause. We don't yet have the probable cause for the search warrant. I'm very curious about that. But
I'm also very curious on the probable cause for the search warrant, because how we get into the home, as I said in my previous chat, I've already said this. I was very clear on this in the previous discussion too. Like I said, basically there are two great hopes right now. Hope number one is somehow we get the drug amount lowered because it's at 26.6 grams, right? So all we have to do is make 1.5 grams disappear, and we can get to the next rung down, which seems possible because according to the police's own record, their own statements, that weight included the packaging. And so 1 gram is a paperclip. It's not much. So we're trying to make a paperclip disappear, which, seems plausible. So, hey, there's a pretty decent opportunity that we might be able to get this dropped from 2nd degree to 3rd degree by pure operational law. And wouldn't that be nice? And then the other one I said was, we can go attack the search warrant. And then I said, the search warrant and the search warrant affidavits, which I said, it's like, yes, we can go do those. I'm very curious on those too. So we share a very serious curiosity.
You go to the probable cause for the initial detention, and it basically says a pastor came and reported concern for the children. That normally leads to a wellness check. That doesn't normally lead to search warrant, knock down your door, arrest everybody inside. So my first is, and not only that, there was a week delay. So, I mean, they're seriously concerned for the children, so they do nothing for a week.
Can I stop you there? Actually,
So, yeah, I mean, I tend to agree. The way they went in with the battering ram is much more suggestive of a drug search in the first place. So the mandatory reporter said something that, perhaps didn't lead to a concern about an immediate crisis, because just because a child is in some sense in jeopardy doesn't necessarily mean that jeopardy is necessarily imminent. So, and I'm not, the finer point expert on such things, but of course the police and other law enforcement authorities have to prioritize to some degree, and they can't be everywhere at once. So as they're trying to figure out what cases require what treatment in what order, they may have evidence that a child is in some sense neglected, but perhaps doesn't require the most immediate concern. For example, as I sort of alluded to, I would imagine, although I wouldn't know because I'm not the head of child services, but I would imagine that if child services had, on the one hand, hey, there's a case in which kids may be present at a place in which drugs may be available. And number two, we have evidence of a kid being beaten because, we have bruises on his body or whatever, right? Or we have evidence of obvious neglect because he's coming to clothes in school in rags. Or, he's obviously incredibly sick and he's not been to the doctor, and so forth and so on. I would imagine that CPS would prioritize these differently. So it may very well be that this was something that the mandatory reporter was required to report. It may very well be that that was not in a imminent threshold. It may very well be that that was not enough for a child welfare check, or it may be that the mandatory reporter said things that allowed them to then develop a more complex case over the course of the week. But we're all speculating because we don't know what the search warrant affidavit has to say because we haven't seen it yet.
First question, when I heard that, because at first I read that it was a pastor who requested a wellness check. I forget what the term is. And my first reaction to that was, isn't that the type of thing that should remain confidential? If indeed, I don't know if Nick is talking to the pastor, isn't that confidential or privileged? And not, there has to be exigent circumstances for a pastor to violate whatever rules of secrecy he's bound by.
I have long opposed mandatory reporting laws.
Okay, so because he apparently is not going to answer the question, I will. I'd have to double check the number, but I believe the number is something around 20, give or take. But in around 20 states, give or take, priests and other pastors and other religious officials are also mandatory reporters. They didn't used to be. This largely changed as a result of the Catholic Church scandal in a lot of states, as you might expect, where priests were shuffling around kids and not reporting on things that they knew and so forth and so on. So a lot of states, not necessarily all of them, but a lot of the states that have it are as a result of that, because of that scandal. So yes, priests, pastors, other religious officials are now mandatory reporters in something like 20 states, I think. The number isn't important. For our purposes, the fact that Minnesota is one of them is really all that matters, but that's what the state of the law is on that, in case you care.
And I understand where they originated. They originated out of concern that child abuse was being unreported by people in a position to know, particularly medical care providers. Mm-hmm. The problem is it has got to such a length that people cannot seek out counseling. So that I dealt with this with another client where I had to advise them, you can't get counseling.
Yeah.
If you go get counseling, then you may disclose something to that counselor that can now be used against you.
I share Robert's point on this, and I've shared similar concerns and some similar skepticism of mandatory reporter laws for exactly this reason. And this all started, I think, with Tarasoff versus Regents of California was where it started. The psychologist at the University of California was a practicing psychologist, and he has a patient who told him that there was a threat to another person, and the psychiatrist tried to treat him but didn't tell anybody. And then, you know, that case went forward, and ultimately it resulted in a determination that psychiatrists must warn law enforcement and or the person who's threatened about the threat if they learn about it, if it's clear, present, imminent threat. And the problem is that the really smart people, myself included, know this. And it's made it difficult for me in the past personally to seek therapy at times, because somewhat ironically enough, the more and more like mentally compromised I've been as I've dealt with depression, the more and more I've had issues with depression, the deeper and deeper I slide into depression. In some ways, it makes it harder for me to seek therapy, because I know that if the therapist determines that I'm a threat against myself, they're going to take actions against me that I might not like. So what do I do as a smart person? I don't seek therapy, which then just causes me to seek deeper into depression. And around we go. And around we go. So I share this concern. I think it's a very practical concern. I'm not sure whether or not anyone has done sort of any meta-analysis at any point about whether or not it's for the better good or not. You know, whether or not it's for the good on the whole that we provide these requirements. Whether or not it's on the good that on the whole that these people have to report, because it deters people from potentially getting help and potentially ameliorating harm because they're concerned about their own liability in a legal sense. So, you know, yeah, I share a lot of his concern. I don't know whether or not globally it's been worth it or not, but the really smart people, and I think Robert's right. I can totally see it. I've basically given this advice to myself. Being my own lawyer, I've given the advice to myself that I shouldn't go to a psychiatrist because I was too concerned about the legal problems. So, yeah, I understand exactly what he's talking about.
Shouldn't be the case. We're supposed to have provider, petitioner privilege, both in the context of ministers and healthcare officials. And yet these laws are overriding it. And it's always done in the name of, let's protect children. It usually leads to children being in more harm because people in a position to seek assistance don't. So I've not been a fan of mandatory reporting laws. But the second aspect of all this is what that's supposed to lead to is a wellness check, not a search warrant and raid of somebody's home. So
it depends again on what the person says, whether a mandatory reporter or not, incidentally. So it depends on what the person said. Now, he might have made a mandatory report for some reason. And perhaps he also said, perhaps as an aside, who knows what he thought the problem was. Perhaps he said it as an aside. Oh, that I think that they're drug users. And the police decide to run with that and investigate that. Who knows? But of course, once you're talking to the police, right? Once you're talking to the police, they will choose what to carry about. Incidentally, I think it's funny in this domain, of course, or ironic perhaps is a better word for it, or just messed up. Although you're, of course, you're required to report, the police are not required to do anything about it. Because no affirmative duty, remember? And it's weird, isn't it? Because the reporter has an affirmative duty. They're a mandatory reporter. They have an affirmative duty. They have a duty by law to make the report. Do the police have a duty to follow up on that report? Do the police have a duty to do anything in relation to that report? They do not. No, so it's like, it's just a weird thing. So yeah, they could be actually, cognizant of immediate jeopardy. If they decide, we're not going to do something about it, it's like, so there's, some sort of disturbing reality in there somewhere.
That is, I find, and the question is it a coincidence that the judges involved apparently in this effort are judges that Nick has been very publicly critical of?
My understanding here is that, and this could be wrong, although I don't think it's wrong by much. My understanding is that there's something like 3 judges in the county, which totally makes sense. I've been to his house. He lives in the absolute middle of nowhere. So yeah, is it weird that it's one of the judges that he's criticized? Well, apparently not, because we are at a we're doing our we're doing our revolver spin, but with 2 bullets in the chambers instead of one. 1 out of 3 odds. It's not great.
Questioning not only their competency but their ethics. That it involves a prosecutor's office that Nic has been publicly critical of, exposing issues of corruption and competence, and a police department he has been publicly critical of, exposing corruption and competence.
And to stop you there for a moment, because I heard the same thing as well, and I had the same queries that you had. Apparently,
you're not going to make a First Amendment retaliation claim. It's just not going to happen. You're not going to happen, right? Because I'm assuming, but I think I can safely assume, right? I'm assuming that the police were told in some capacity that there was some evidence that Nic was a drug user, perhaps because someone saw something, and they decide to use that basis for investigation, and that's enough, right? You can't really get into the motives of the cops. It's almost impossible. And that's just generally true of police officers, generally speaking. We don't look into their motives. We look into whether a reasonable officer would have objective reasons to conduct the action they did. And you don't go into the motive of the thing. It's basically impossible. So as long as the police if someone came in the door and gave them information that would lead a reasonable officer to be able to conduct an investigation, which how much evidence do you need to have an investigation? Basically 0, because the police can do an investigation based on, based on a dream they had. The tools of the investigation obviously are going to be different, but their wish to do an investigation doesn't require really anything. So as long as any information came into their door in sort of any way that would allow them to do an investigation, then assuming they followed all the steps that the investigation would go through, you're not going to get it on a retaliation claim. It's just not going to happen.
The judge assigned to Nic's criminal case is the same judge who's involved in his civil case, the defamation case, where he's been a vocal critic of her. And I had the same questions, like, how the hell is a judge doing both criminal and civil? But many people say it's a small town, so maybe they're not that many judges.
Well, that's the issue. You have the biggest high-profile critic in a small county of all these powerful actors. Like, people ask me now and then, why do I live in Las Vegas? It's because I don't practice law in Las Vegas. I don't practice law in the state of Nevada. It provides a degree of protection from if you know anything about Las Vegas police, you would know you'd want to be careful. If you want to practice law in Nevada, don't live in Nevada.
I think there's probably quite a lot of lawyers in Nevada and even in Las Vegas that practice law in Las Vegas. I'm pretty sure. If I had to make my bet, I would think that Las Vegas might have a somewhat higher per capita representation of lawyers than, for example, any other given city. Given some of the things that happen in Vegas, for which Vegas is quite notable, I would think that their lawyer population might be somewhat above the norm. So I'm not sure what that's about, but okay.
I'll put it that. We'll get to that when we get to the Gruden case a little later on. But so I have First Amendment case questions. I mean, were biased, prejudiced, partisan officials part of the entire process? We'll get to this when we can talk about the Trump case, and authorizing and approving this extraordinary search warrant. Then
that's not going to happen. The First Amendment argument's not going to work. It's not going to work. As long as the objective indicia are there, you're not going to make a First Amendment retaliation claim. It's not going to happen. And you can imagine why. Obviously, it's a matter of law, because you don't want to incentivize a criminal to be like, well, you know what I'm going to do? I'm just going to go out and openly, blazingly insult everyone and be the biggest ass possible, right? I'm just going to do everything possible within the bounds of law to make myself the biggest, most objective, most obtuse ass known to man. That way, when I do the illegal thing, they won't be able to come after me because it will all be retaliation. You should be able to anticipate that the law is not going to allow for this to occur. So, no, it's not going to happen. If they have the objective indicia, the First Amendment argument is not going to work. I appreciate his effort and all, but no.
Then you get to and that could be discriminatory, selective, disparate under the First Amendment, all legitimate issues that also President Trump has.
Do you know how hard it is to make a selective prosecution argument? You see, he just says that. He rolls it off the top. Like, he just says it like a thing. It's like, do you know how hard that is to make a selective prosecution argument? To make that the prosecution is specifically targeting you because they don't like you in particular? You know, keep dreaming, man. Keep dreaming. It's not going to happen.
Raised in all of his cases. Then you get to the Second Amendment issues.
The Second Amendment issues don't work either. And I'm a Second Amendment guy, but they're not going to work. But we'll discuss why.
Curious, I was like, okay, why is there a gun charge here? He legally had the right to possess the guns. He's got no criminal history of any category.
Correct.
And I thought, well, there must be something in the probable cause for detention that will say the guns were in the presence of the children or something like that. Nope. It's in his private bedroom, his personal bedroom. In the bathroom of that bedroom is where they found the substances and where they found a gun and some ammunition.
Yep.
It's like, how is that grounds for under the Second Amendment to charge anybody with a crime?
Okay, so to answer his question, because by being an unlawful habitual user of a controlled substance, Nic would be allegedly, therefore, a prohibited person under both federal law, and of course the states are allowed to make it a prohibited person under the state law as well. We looked this up, of course, the other day, 18 U.S.C. 922 G3. If you are an unlawful user of a controlled substance, you are a prohibited person. You are not allowed to own or possess or buy a firearm. It's on every federal form. This is exactly what Hunter Biden is being charged with as we speak. That's Hunter Biden, right? That's the allegation. As a user of a controlled substance, an unlawful user of a controlled substance, he bought and possessed a firearm. That's what he's being charged with. Of course, his lawyers, by the way, have made the exact same defense, that this is unconstitutional. And I do enjoy the rich irony that if it winds up being Hunter Biden who somehow wins this one for the gun rights people, the irony of that will be very delicious indeed. The irony of that will be very delicious indeed if it's a Biden who makes it possible for drug users to own guns. That being the case, however, although the irony is particularly rich, I do not feel very optimistic about this possibility. The reason is that the case law is just simply not set up for it at this time. Every Second Amendment person who knows anything about the case law and knows anything about the courts should have absolutely no problem agreeing with me that the courts, generally speaking, are not super enthralled with the Second Amendment and do not give it the same kind of love as a practical matter that they do the other amendments. For example, the First Amendment gets something like 3 to 5 cases every single year by the Supreme Court. Every single year. There's like 3 to 5 First Amendment cases. How many Second Amendment cases are there on a typical year? About 0. Right? And the hostility of the lower courts also should be no surprise to my friends in the Second Amendment arena. Although, of course, there are exceptions. But generally speaking, the lower courts are not exactly super thrilled with the gun rights. And the fact that there are cases to the contrary is notable because they are the exception, not the rule. So the case law is simply not set up for this argument at this time. And it is pretty impossible for me to believe that given the state of the case law, given the foundation, it seems impossible to me that the next thing the Supreme Court's going to be, you know what we're going to do? The next step in the Second Amendment, restoring the Second Amendment, the next step is, let's say that drug users have the ability to have guns. Okay, that might be a decision the Supreme Court makes someday, maybe, but is it the next thing in the sequence, right? We had Heller, hey, you have the right to a handgun in your home. Hey, if you're in DC, McDonald, hey, you have the right to a handgun if you're like anywhere. And then we had Bruin, hey, maybe you have a right to carry sometime outside, maybe sometimes. Okay, do you really think the next step in that train is, oh, also the drug users get the guns? I am very dubious. So the case law is simply not set up for this argument at this time. The 922 G3 thing exists. The state law analog exists. The problem is that he's a user of drugs who has possession and ownership of guns. That is the problem. And that is the state of the law. And he can't win that argument. There's this, especially out of Minnesota. You know, if there were going to be a state where he could win that argument, Minnesota doesn't exactly strike me as the most plausible. right? If we are going to find a state to agree with that idea, Minnesota doesn't exactly peak at the top of the list of states in which that argument will fly. So I don't think that argument works.
And then you have the bail provisions that say because you've now been charged with this crime, you have no Second Amendment rights. You lose your right to possess a gun in Minnesota under their regular routine conditions of bail in Minnesota. That strikes me as violating the Second Amendment. And we've discussed
that's a more viable argument, but the only way that argument makes sense, first of all, it only comes up if Nic didn't post bond, because if he posted bond, it's unconditional. And I don't know whether or not he posted bond or not. I simply don't know. And I think he could change his mind, incidentally, between the two. I think he could change his mind. So if he posted bond, then he doesn't have to do that. And so you could argue there's a waiver. Now, you could try to argue unconstitutional waiver. But the only time I've ever heard of an unconstitutional waiver argument happening is in a First Amendment context. I've never heard of it working in any other context. So you can make a context of like, a waiver is just like you give up any right, right? You allow the police to search your home. You give up your Fourth Amendment right. You decide to talk to police. You give up your Fifth Amendment right. You decide to whatever, right? So the only circumstance I know of where an unconstitutional waiver has been upheld is like in a First Amendment arena. Like, you don't get this government benefit unless you give up this First Amendment right, the right to freedom of speech or whatever it happens to be. And those are the only circumstances in which I know that. And incidentally, not even like every First Amendment context, because gag orders, generally speaking, are valid. So this would be like more like a government program that basically, like, I'm making this up, but it would be more like, in order for us to get, in order for you to get food stamps, you have to give up your right to go to church. That would be what we're talking about, right? That would be what we're talking about. Yeah, you can't do that. You're not entitled to the food stamps, but it's unconstitutional to say to get it, you have to give up your religious rights. So short of that, no, not so much. So so the waiver argument's probably better anyway.
Discussed this before. Remember the Oklahoma case, other cases. There is no constitutional history, and that's the standard under Bruin, of criminally punishing someone merely for possession of a gun, merely because they've also been charged with possession of some illegal substance. It's only been illegal use of a gun at the time you possess or are under the influence of illegal substances, or under the influence beyond the range of what's legal, such as alcohol, and usually in a public place. And so I think that the criminal charge of the gun charge against Rekeita patently violates his Second Amendment rights. I think the bail condition violates his Second Amendment rights.
Well, the gun.
All right, so he says he makes two statements. The first is that it's there's two implicit arguments at least. The first is that it's against the Constitution in some sort of pure sense. All right. So if we were to properly understand the Constitution, if we were to properly apply the Constitution, if the Second Amendment actually had the meaning it's supposed to have, it would be unconstitutional. Now, to this point, I don't know the answer, because the Supreme Court has said the right test is history and tradition, which I think is correct, because that's how I think we should interpret all the Constitution. History, tradition is how we understand it. We're looking for the right to keep and bear arms. What is the right to keep and bear arms? Well, we understand the history and tradition because that's what they were talking about. Great. So if we want to ban, let's say, so we want to pass a law that says, hey, if you're a user of drugs, not necessarily high right now, not necessarily intoxicated right now, but if you're just a user of illegal drugs, like generally speaking, you can't have a gun. All right. So we want to pass that law. How do we determine if that law is constitutional? Well, the way we would do this in like pure Second Amendment land is we would go back in history and tradition, and we try to determine the degree to which people were restricted from owning guns, possessing guns, displaying guns, using guns, whatever, while, let's say, under the influence of anything, right? And we try to look for the historical record on that and try to reason by analogy. And I don't know the history that well. That's where you get into all the briefing, trying to determine whether or not that is, what the consistency with it. So it may very well be the case that the case law only supports these type of bans if you're already like while being under the influence, but not if you're not, or only in a public place, but not if you're not. So that might be the correct statement of the Second Amendment law, but I don't know that. But even assuming that's the correct statement of the Second Amendment law in like the pure sense, the courts are just simply not ready to go there, as I discussed, right? So even if that's the ultimately correct decision, the courts are not ready to go there. And in some sense, it would be foolish for a Second Amendment advocate to try, because it's too far a leap. And we're trying to build up something that doesn't have a great foundation because the courts don't love it, right? We're trying to nurse this thing that's been neglected so badly. It's like a little baby bird that has his wing broken, okay? And you're like, this bird should be able to fly. I'm like, okay, I appreciate it all that this bird should be able to fly, but it's a little baby bird right now with a broken wing that can barely take care of itself, and we got to bring out the eyedropper and feed it ourselves one step at a time, okay? So one of the problems that the Second Amendment people, generally speaking, have is they want to go all the way to the end of the page, which I understand. I get it. I'm a Second Amendment guy. I'd like to have the full Second Amendment rights too. I totally understand. But you're trying to just do too much too fast, and you have to worry about the possibility of blowback. So I think it's a mistake, generally speaking, especially given the, let's say, timidity of the courts when it comes to Second Amendment rights. Given their general character and their timidity, and they're very slow going, I think it's a slow, hard one, very, very paint by numbers exercise for the foreseeable future, as frustrating as that is. So that is my opine on this issue, and I don't think that you can win this argument at this time.
One charge is a gross misdemeanor, so 364 days maximum sentence. The big one is the possession of a controlled substance.
The other thing is they use it as an enhancement for sentencing purposes on the drug charge. So there's a dual level influence of that particular aspect, and there's no allegation of any illegal use of a gun. No allegation that he used the gun in a public place. No allegation that he used the gun while under the influence.
The report mentioned a spent shell, which was near the Glock, which I don't. It sounds scary. Was he discharging the weapon, the firearm in the house? The bail, Robert. We had the same two questions, I think, as well. And if I made a mistake, I'll correct myself on Twitter. They were saying 50,000. What was it? Unconditional. It was a UR. There was a
great question. Chat says the cheeseburger. This is a good opportunity to talk about this a little bit since I have so many of you here. Does the Constitution talk about the restrictions of rights? Okay. The first question you have to ask, and this is a very interesting question, and it's a very precise question, so I'm going to take some time. Okay. The very first question you have to ask is, what exactly is the right? Because before you can even talk about restricting it, you first have to define what the thing is. It doesn't make any sense to talk about restricting it until you first define what it is you're restricting. And the way I sort of analogize this to make the point would be like, okay, I have a right to the land. Okay, and the government wants to put some kind of restriction on the land, whatever it is, zoning ordinance, they want to do whatever. They want to do a restriction of some variety to the land. Okay, but without knowing what the land is first, what the hell are we talking about? Right? Because my piece of land, the land, is not the land over there. Like that piece of land over there might be land, but it's not the land because it's not the land that we're talking about, right? So you have to define the land. You have to define its borders and what's inside or outside. So if we're restricting things over there, even though it's land, it's not the land, okay? It's not the land because it's not within the borders of the thing. All right, so the first thing you have to do when it comes to the Constitution, at least in my humble opinion, whether it's the First Amendment or any other right, is define the thing. And that's why the Constitution uses the word the, which is a definite article, as opposed to the word a, which is an indefinite article. It doesn't say a right to keep and bear arms. It says the right to keep and bear arms. There isn't a right to freedom of speech. There's the right to freedom of speech. The word the becomes very critical. The word the is a definite article. It is referring to a specific antecedent. It's referring to a specific established thing. It's the difference between give me a apple and give me the apple. If I say give me a apple, any apple will do. If I say give me the apple, there's a particular antecedent apple that hopefully you know exactly what I'm talking about. And if I don't get that one, I'm going to be disappointed because that wasn't what I asked for, right? So it isn't so much necessarily, although there's that too, about talking about what the restrictions are. First, you have to define the thing. And so, for example, I think the gun owners generally make a mistake. For example, the Second Amendment people generally make a mistake because they want to go to shall not be infringed. But I don't think that's actually the most interesting question. The most interesting question isn't shall not be infringed. The most interesting question is the right to keep and bear arms. Because if it's not the right to keep and bear arms, whether you infringe it or not, it's irrelevant. So you first have to figure out what the right to keep and bear arms is. And how do you do that? By the historical reason. It's for exactly this reason, incidentally, when it comes to the First Amendment and we talk about the freedom of speech. For me personally, I wouldn't consider something like defamation an exception to freedom of speech. I just don't think it's within the boundaries of at all. I might speak the defamation, which is slander, right? I might speak the defamation, so it might be spoken, but even though it's not speech within the meaning of the freedom of speech. There's a difference between speech and the freedom of speech. Defamation is not included within the freedom of speech, even if it's spoken. It never has been. It was never included. It was never thought within the thing. It is a categorical error to say it's within the category of the thing. It's a term of art. And so you're restricting your right, or restricting your ability to slander is not an affront because it is not part of your First Amendment rights. So the First Amendment's irrelevant because it was never included in the first place. And around we go. But that's deep level constitutional law analysis for you today.
So, an acronym they used. And it sounded like it was $50,000 bond or all of these conditions, when in reality, what was agreed to was $50,000 and a bunch of conditions, correct?
No, it's or. So Minnesota's unique. Most states, that's always an and. In Minnesota, I can tell you why they're doing this. They're doing this to evade constitutional challenges. Though they don't evade it in the process. Because you can't impose a monetary fine on the assertion of your constitutional rights or remedies. That would be a form of unreasonable bail under the Eighth Amendment, just as it would be an excessive fine if it were a fine as some form of civil or criminal punishment under the Eighth Amendment. What they're doing is they're setting themselves up to make it easy. Say, you didn't have to apply any of these conditions as long as you posted bail. They give the two options. Either you post bail, and then you have no conditions on you. None. Or you agree to the conditions and then you're out on your personal recognizance and you don't have to issue. And the theory is that either one will secure your appearance later. How does taking away somebody's Second Amendment rights secure their appearance later?
But then, I mean, why wouldn't the options? I thought they were alternative, and then I thought they were cumulative when they were agreed to. It was $50,000 bond, which he would have only had to post 10% and get the rest by a bonding company, or these conditions. Or these
depends on the jurisdiction. There's some places that are pure cash bail where you have to post the whole amount. Like
Wisconsin, for example, where Kyle Rittenhouse, for example, had to post the entire amount, just in case you're curious. $2 million bond. He had to put up $2 million. There's no 10% thing in Wisconsin. Just as long as we're here to learn something.
I think in Minnesota, you can get a bond agency to post.
Okay, so he agreed to the conditions, which include travel restrictions, drug testing, what else?
But also loss of gun rights.
My own question was, independently, what happens if someone's out on bail and then there's a random drug check or alcohol test check
they try to, that raises separate Fourth Amendment issues, always has. Drug testing while on bail, to me, is also unconstitutional. It's arisen in the probation context, even. The Ninth Circuit called it an unconstitutional condition. So in my view, that's, again, and what they're trying to do.
I don't know under what circumstances the Ninth Circuit called it an unconstitutional condition, but I'm willing to bet they didn't say it as some sort of broad-based proposition. Because if they had said it as some sort of broad-based proposition, I think it would have crossed my attention. I mean, I'm not to say that I know every single law ever, but I would think that if the Ninth Circuit said, hey, by the way, drug testing is no longer a thing when it comes to probation or parole or bail conditions, I would have thought that across my desk. So either one, I missed a big memo, or two, perhaps it isn't that big a memo and it's being taken a little out of context. Not sure which, but yeah.
Is use scandalous or sensational facts to slowly strip us of all of our liberties and rights. They're trying to use bail as a control mechanism. And so that's its own independent problem. The same with controlled substances. For those folks out there that might be like, well, I really hate particular substances, don't think person should ever use them. Okay, just remember right now the state of Pennsylvania has already said that having Amos Miller's raw milk in your refrigerator is the exact same as having any illegal drug in your possession. Now imagine if they could use, you have Amos Miller's raw milk in your fridge as grounds to strip you of all your Second Amendment rights. And then we get to the next charge, the child endangerment charge. I assume there was some connection. There's none. They're simply saying if you possess an illegal substance, we're going to call that endangerment of a child.
That's true. That's what they said.
That strikes me as a Fifth Amendment violation. Because under the Fifth Amendment to the U.S. Constitution, the most fundamental of all fundamental rights under the Due Process Clause, as the Supreme Court itself has acknowledged many times, is the right of a parent for control, custody, and care of their children, for them to make those decisions. That can only be invaded if you showed harm to the child. There is no allegation at all that he has caused any harm to his children ever.
And now, so let me.
Well, okay. He's stating it poorly at best. Okay. When they talk about that kind of thing, they're talking about the ability for the state, for example, to remove the kids from the home, like in a family custody sense, in a family court. That's what they're talking about, right? So when they're talking about that, they're talking about the ability of a parent to mind their child, care for their child, and things like that. And if we're going to remove a child from a home, remove them from their parent, we need clear and convincing evidence. That's the correct legal standard. And we need to be able to show that there is harm to the child. That would be correct if we were in some sort of removal proceeding. But we're not in a removal proceeding at the moment. We're in a criminal process with respect to him. And the concern would be the potential threat, which may not be enough to remove the kids from the home, but would be potentially enough to say this is unsafe. And you could imagine that like any number of scenarios. Like this is not like we can take drugs completely out of it and go to some other scenario. Like you could just imagine a parent doing something, whatever it is, letting their child just completely run free, like unsupervised in a construction zone with like heavy moving equipment around while they're drinking alcohol. Right? So if we catch you doing this and you try to say, hey, the kid hasn't been run over by, the truck yet. That isn't going to work. You had an ability, you have a responsibility as a parent to care for your children and mind for your children and to keep them safe. And if you, through your actions, create a situation in which your children are being recklessly endangered and you consciously disregard that risk, which is what recklessness is. Recklessness is conscious disregard of a known or readily foreseeable risk. That's what recklessness is by definition. So if you create a reckless situation by your kids, the government's going to have a word with you. They may not be able to remove your kids from you, but we don't like that. We don't like parents who are reckless. And it's like, well, my kid is just as fine as they all were. The truck hit them. The truck hit them with, the truck hit them 30 miles an hour, and my kid went flying through the air, and then he landed on his feet, and he's like, ta-da! And everyone's happy, and everyone applauds, right? I mean, we're gonna have an issue with this thing. So, the idea here being, of course, that the drugs being present creates a readily foreseeable risk that a reasonable person would readily be able to foresee that having drugs in the presence of a child might lead to the children using those drugs or having or getting access to the drugs, and it puts the children at some sort of jeopardy. So I think he's right. He's right insofar as we were talking about removing the kids from the home, but I think he's wrong insofar as he's talking about our ability to go after parents because they are creating situations that are not good. So that's where I would critique that.
The government. I'm just going with the government's own probable cause declaration.
Well, no, and that's what I was going to say. Is like there's a lot of, well, say the quartering, for example, says, Nick has been blackout drunk, and then 4 hours later talks about driving his kids around. You're not sober within 4 hours, whatever.
See, that would definitely be the kind of thing that you would get your attention of. If Nic Rus said that, which is my understanding that he actually said that, that would definitely get that would be a kind of thing that might lead the government to think that maybe there should be a check on the kids. Hey, I get completely blackout drunk, and then 4 hours later I put my kids on my car and I drive them around. That might be the kind of thing that might get the government's attention if they came into access of that information, I would imagine. Yeah.
A lot of other people have seen what I'll call the public meltdown, which I think is related to alcohol abuse at the very least. And infuse that or combine that. Whereas from the state's perspective, that it's not like they even referenced the streams.
Exactly. If that was the basis, it would have been in that. See, I thought they had some independent basis for this. They had none. All they did is some, and this will get to the Fourth Amendment issue now. I thought there was something more here. Not, okay, you found something in a dude's bathroom, and that's it. All of a sudden, you're going to take that as a grounds for a search warrant. You're going to take that as a grounds to take away Second Amendment rights.
Yes. Okay, so we sort of discussed this possibility too. So there's two possibilities here when it comes to how we got into the house. By the way, while I'm thinking about it, because I saw a couple people say this in comments, and it's, just generally speaking, there seems to be some people out there who seem to be of the belief that if there's an allegation of child neglect, that means that the police / CPS / whomever can come into your house like without more, which no, I mean, obviously not. That would be incredibly stupid if that was the law, right? Okay, the police need the ability to search someone's house. What are they going to do? Oh, there must be a child in danger, right? Back down the door. That doesn't work, right? So if we're going to get into the house, we need one of two things. We either need probable cause, or we can have consent, I suppose. So we could have consent, and there's some other exceptions, but let's keep this simple. We need one of two things. We either need probable cause or we need consent, or imminence, or an imminent threat. An imminent threat would be the third thing. Okay. So scenario number one is we're standing at the door. We hear a child in distress. We break down the door. We have imminence, right? An imminent threat. That would do it. But unless we have an imminent threat, we need a search warrant to get into the home. The search, we need to get into the home. So there's two possibilities here. They had a search warrant to search for evidence of child neglect. But once they're inside the home, they found evidence of drug use in plain sight, which is to say, as they were going around, looking around in any place they had the right to look, which would be at a minimum, like in every bedroom and the bathrooms and stuff, to look for evidence of child neglect. If they happen to see evidence of drug use, and then they use that as a basis for searching, then you're there. Because the drug in plain sight is now is probable cause to believe that there's drugs in the house. I believe there's drugs in the house because I can see them right here. Okay, now I'm going to go search for drugs because I just found the drugs, right? So I'm going to go search for drugs in everywhere. So that's possibility number one. But possibility number two, which seems a little bit more likely under these circumstances, is that they were there for the purpose of drugs. The reason I say that is because they brought out the battering ram, which seems like, more of a drug search kind of move to me. But either way, you'd want to know the basis for how we got in the house. You want to know the probable cause thing. So, yeah. But, it is not the case. It is not the case that if CPS, it is not inherently the case. It is not inherently the case that if CPS shows up at your door and be like, I have concerns about the kids. Can I come in? And you're like, no. Can I see the kids? No. It is not inherently the case that somehow magically gives the police probable cause. Okay, if they had probable cause otherwise, then fine, right? But if they didn't, then they don't, right? CPS does not get a get out of jail free card when it comes to search warrants, is what I'm trying to say. Because there seems to be some people out there who seem to be of the belief that if child welfare is involved, or if there's a child welfare allegation, apparently the Fourth Amendment goes out the window. That is not a thing. Just want to make that clear.
Going to take that as grounds to take away care, custody, and control of children. You're going to use that to let child endangerment? When I read the statute requires the child be in the presence. They're interpreting that so broadly that they can basically take away anybody's child if any substance you're using they don't like. And remember, the state of Pennsylvania includes Amos Miller's raw milk in that. That's how nuts some of this is. It violates constitutional rights, and they're using the scandal and sensational facts. And
Brightfire said, would refusal CPS cause further investigation? It very well might, which is their prerogative. So if you refuse, if they come and knock on your door and you say no, and they'd like to come in your door, then yeah, they might very well do a new continue their investigation. That's the prerogative. And if they find new evidence and they can find probable cause, then great, of course. Yeah. How's the Eighth Amendment apply? The Eighth Amendment would apply to excess bail. It would apply to the $50,000 that he was initially assigned, and saying that's excessive would be the Eighth Amendment argument. which I think, incidentally, there's a valid point to be made when it comes. I don't know how far it would get, but at least in principle, bail is supposed to do two things. Bail is supposed to, in principle, two things. One, ensure your appearance to the court, and two, protect the public. Right? Those are our twin concerns. Hey, we want you to show up to court. Hey, we want you to stop hurting people. All right? So the money in bail is supposed to be tied towards those two goals. And so you can make a very credible case that $50,000 in this particular case is not sufficiently tied to those two goals. So you can make the argument that $50,000 is excessive in this particular case. That's an Eighth Amendment argument. I don't know how far it gets you, but you could try. But that's the idea, is that it's excessively high. And I think you could make a credible case it is. And you could arguably try to get that reduced as a result, if you were so inclined. And maybe you will get that reduced. But that's what the Eighth Amendment argument would be.
People like the courting misunderstanding the facts to try to get away with a severe deprivation of constitutional liberty.
Well, no, I think a lot of people are joining what they know personally and what they've witnessed over the last little while with the law. So they're saying, okay, well, I know all this stuff.
That's where they're like, no one has witnessed anything bad, but I assume they had these facts. They don't. Anything negative towards the children at all, other than they thought the house was messy. And I was like, hold on a second. That's not grounds of alleged child endangerment. I mean, I commit it every other day if that's the case.
And like that, the document says,
weird
dirty
flex
dishes and the house is sort of in disarray. I'm like, crap.
Weird flex on that one. That I put my child in jeopardy every single day. By the way, as long as I'm here, we have a new Instagram thing that we're trying out where you can get notifications of these streams on Instagram. So I'm going to go ahead and pin that link, so that if you'd like to get notifications via Instagram of me going live or otherwise doing stories and stuff, I'm trying to make a point of posting it there, because sometimes people don't get notifications through YouTube. We post the notifications obviously through YouTube, we post it to Twitter, we post it to Discord, and in the effort of getting you guys more notifications, I created an Instagram group so that you can get notifications there too. So if you'd like to sign up for that, we're giving that a shot, so you can check out the pinned comment. Thank you, by the way, for everyone who's here. Let's resume.
Someone comes through this at my house and says there's dog poo and streaks of dog, but they won't know it's dog blood, but like one of our paralyzed dogs, she sometimes bleeds and drags her feet around. And I mean, that much I'm very skeptical of. I think what a lot of people are doing is merging what they have seen personally and publicly of Nick with these charges.
In the live chat where people are saying, well, I know this in general about people who have problems with alcohol or drugs or gambling or other abuse, addiction related issues causing issues with children. Yeah, but we don't presume things like that. We don't assume that everybody that has an issue, you have to prove it with actual facts. And, that's the problem here. Well, now we get to the Fourth Amendment problems next.
Oh, before you get to the Fourth Amendment, let me just throw this in, because people say, look, a pastor was so concerned. He said a wellness check on the kids, and there has to be a good reason for that. Who the hell knows what information the pastor had? We are living in a world where I'm not trying to be over cynical.
Well, I thought there was more detail. I mean, that's where I thought, okay, this is a detention warrant. This is saying this is the grounds for all of this. And I thought, okay, there's going to be a lot of details of what the pastor said that really precipitated serious.
No. It wouldn't be in this warrant. That doesn't make any sense, right? It wouldn't be in this probable cause. We have two probable cause statements, one of which we haven't seen. Okay, we have probable cause for the detention. How do we get in the home? We don't know yet. That's the thing we don't know. And presumably at some point in the near future, we will have a copy of it. I've filed an open records request for whatever it's worth. I think it's going to be put on the public docket anyway, so I don't think I'm necessarily going to get early access to it. But hey, why not ask? Because I can, right? So at some point, we're going to get a copy of the probable cause affidavit as it relates to presumably the search warrant. Because presumably we had a search warrant because we broke down the door. And it doesn't leave a lot of other possibilities. The only other possibility would be, exigent circumstances, which does not appear present, because they would have said that, presumably. So I'm assuming search warrant. So there would be no reason to put it in this probable cause affidavit, because the probable cause is, well, we arrested them for possession of drugs. Okay, what is our basis for thinking we have drugs? We found the drugs. How do we think that they're drugs? We did a field test. Okay, I mean, that's enough for probable cause. Probable cause is a low standard. Field tests can be wrong, and sometimes are, but they're enough for probable cause. You know, for the purposes of a trial, obviously they will send off to a lab for a more thorough test, but it's enough for probable cause. We're arresting them for possession. How do we know you have possession? We found it. How do we know which drug? We tested it. Okay. We found children in the home. Okay. Well, we also found drugs in the home. Okay. So that means children were in the home with the drugs. Okay. So that's a violation, right? And it's like, oh, okay. So that's kind of how that comes. So there's no reason to put it in this affidavit. We will see that at a later time, I'm sure. And that will be very interesting as well. Do I know if April's charges are dropped? That is my understanding, yes.
Concern. And that it's not there. I mean, I was stunned it wasn't.
And also the gun, obviously, yes. We found the gun. We found the gun. We also found the drugs. Oh, there's guns in the same place drugs are. Oh, okay. So yeah, there you go.
There. I was like, wow. They saw this as an opportunity to go after one of probably their biggest critic, given how small a county they are. Their biggest critic. They're like, this is a chance to shut him up and punish him for yipping about us for years. That's what I see. Because that pastor's complaint was what was more like, hey, I got a basic concern. It was not, here, this specific. Nothing like that.
He doesn't know that, of course, because he hasn't seen the probable cause with respect to the search warrant either. He's saying that those things are not available. He has no clue if those things are available. They're not in this probable cause affidavit because we don't need them in this affidavit. We need to be able to get into the house, but once we're there, we don't need it anymore. So he doesn't know that. And I'm willing to bet that there's more of that probably than not. Now, I don't know that for sure, but I'm willing to bet it. And perhaps the police took other steps to verify that there might be drugs in the house, whatever those steps might be. So, you know, yeah, I mean, I'm assuming that, you know, they heard it from a reliable source, perhaps did some sort of investigation to confirm that drugs might be a house, or he's a drug user, or otherwise got their search warrant, and blah, 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 and there you go. So, yeah, all right.
There.
And people can say, like, I see some of the chat, like, you're defending them. Even, first of all, even...
I could care less about those people. So I care about constitutional liberty. I want Nick to do well. I want him to get good counsel, all those things on a personal basis. But we're not the shrink show, nor are we the moral judgment show. We're the law for the people show. And we care about constitutional rights and liberties. And guess what, folks? You dig into a lot of constitutional rights. Miranda wasn't the sweetest human being on the planet. So, I mean, you give people that some of our core constitutional rights when they want to eviscerate our rights, they're not going to go after popular people. They're not going to go after people who have the most perfect life history. For those that don't remember, Rush Limbaugh had his own addiction problems. Half of America will either have a personal close relationship with someone or themselves have an addiction problem at some point in their lifetime. So these people that get real judgmental, it's like, hold on a second, this is pretty darn common. Mark Robert does great work in terms of helping people. You can go to America's Untold Stories. He covers that. You can read his book about Rehab Nation. That there's good stuff there. But on the law side, they're trying to eviscerate his constitutional rights. And I see all a law tube that not talking about this. And it's like, to me, once I dug in, I was shocked at what I was seeing.
Especially...
Well, that's because those concerns are premature at best. We don't have enough information at this time, although I highlighted the issue repeatedly in my past stream. I'm not sure if I strictly speaking used the words Fourth Amendment in my past stream, but I talked repeatedly about challenging the warrant. I talked repeatedly about looking at the probable cause affidavit. I talked repeatedly about some of the evidence we might need in the probable cause affidavit. So I'm certainly well aware of this issue. I'm well aware of the possibility, but I don't have enough to analyze it because I don't have the thing yet. I'm like, I know it needs to exist. I know I want to know what's in it, but it's a little premature to talk about it because I don't have it yet. So yeah, I mean, okay. And then like the First Amendment argument doesn't work. The First Amendment argument doesn't work. Retaliation for freedom of speech doesn't work. Selective prosecution doesn't work. The Second Amendment argument doesn't work. So like, yeah, these arguments I kind of didn't make because they don't work. So that'd be why I didn't make them.
Especially in the context of that umbrella guy's covering it. I mean, he's also concerned for what Nick he considers to be a friend, but like they called CPS on that umbrella guy as well. Anonymous calls.
Yeah.
Who knows what information the pastor is acting on? Well, they've got 5 kids.
That's the Fourth Amendment issue.
Yeah.
So I thought, okay. So first of all, and for people out there, when people get swatted, That's usually a Fourth Amendment violation by the government.
The problem there is exigency. That's the issue, right? Because the police are apparently, the issue with swatting is the police are in apparent receipt of information of an imminent ongoing danger, which is the definition of exigency. And the nature of exigency doesn't necessarily afford itself the ability to do verification. And so they take it and they run with it. And so is it a Fourth Amendment violation? It's hard necessarily to make that argument in some situations because of this exigency doctrine. So I understand his point, but swatting creates complications because, well, you don't know if the police get it, they don't know if it's real. And the police have to be cautious because they can't necessarily assume that because the last 10 were pranks, the 11th is therefore also a prank. Because again, we need to get in the mind of a criminal, right? Boy who cried wolf, right? So maybe a criminal's really, really smart and really, really thinking ahead, right? It's like, okay, my intention in the future is to like go and break into this person's house and like start and to terrorize them and whatever. So what I'm going to do is I'm going to fake call the cops 10 times, right? And they're going to go down there with their swatting tools and they're going to go down there and do the rest thing. And then the 11th time when the call is made, they won't think it's real and they won't show up. And then I'll be able to do my thing. So the police are kind of in a damned if you do, damned if you don't situation because they don't know which one is real and they don't want you to know which one is not real. And they're going to get criticized either way. They're going to get criticized either way. They're going to get criticized if they show up and it's not real. And they're going to get criticized if they don't show up and it is real. So, their challenges are manifest. I do agree that in this day and age when it's so easy for people to make these calls, particularly online, particularly anonymously, that perhaps we have to rethink this doctrine a little bit. But that's really a concern that needs to be done by the legislature on some sort of global level because it's a policy problem and we need to rethinking about this from a more like systematic viewpoint. But I digress.
The government can't rely on anonymous information, third-party information, hearsay information as their sole basis to go and...
Mango says, I'd like shit that doesn't happen for $500. Well, the example might be a little bit extreme, but it does absolutely happen. Criminals do penetration tests too. It's a penetration test, right? It's a test to see whether or not I can gain access at a later time. So sure, some smart criminals absolutely rehearse and test. I mean, those are particularly sophisticated criminals, but yeah, it happens. It happens. They rehearse, they plan, and they, it happens. Yeah.
Take a ram and bang down your door in your house, right? That's not what is allowed under the Fourth Amendment. You have to have probable cause of a crime, and under internal public policy, it's discouraged. We'll get to this when we talk about Trump and Mar-a-Lago. Yeah, you got to be discreet when you're executing search warrants. Okay, search warrants should be for exceptional cases, right? That's drug dealer cases. How many times have you heard of a search warrant being executed on a first-time alleged a drug user? I mean,
well, it's not necessarily clear what the police knew in that regard in advance either. First of all, they legally can, and second of all, it's not necessarily clear what evidence they had in advance. Maybe they thought, because it's not clear what they thought was going on. But yeah, I mean, the police can look for drugs. Obviously, drugs are illegal. And they found drugs that at least surfacely are second-degree offense. And we think that might get that. So it's like, it's not an inconsequential amount of drugs, at least from the state's concern. So also, that's just like an emotional reaction. It's like, oh, it doesn't really count. That is not how that works. And if they thought there was 1 gram, they could get a search warrant because it's illegal, and they're allowed to look for the illegal thing. So I mean,
I mean, this is very rare. I'd be curious how often they've done it in that small county. So again, going to the First Amendment issues, but what was their basis for probable cause? So the pastor doesn't have any firsthand information, doesn't report any firsthand information. Okay, so now you've got and he's reporting it from somebody else. So he's like, you got third-hand information. If the information may be privileged in the way in which he got access to it, which raises its own separate set of questions, he apparently had no detail. I mean, it's of any actual neglect or abuse. He didn't say, okay, that the child is having this problem or this problem. None of that. It's, hey, I think that there may be...
Nate the lawyer points out in chat. Thank you, Nate the lawyer, for joining me. Barnes does not know that you can use hearsay at a grand jury to get an indictment and not trial. That's true. You can use hearsay. The hearsay rules are evidentiary rules for trial. They're not necessarily the rules that apply at other stages of the proceedings. The reason, incidentally, like on a technical level, is because our level of confidence, generally speaking, increases in basically every possible dimension. So sort of at the end of the day, right, we need proof beyond a reasonable doubt. That's ultimately where we're trying to get to. And the evidentiary rules, obviously, for then are at their tightest. The very beginning of this thing is the police want to do an investigation in which we basically need no evidence of any kind, and the police can kind of do anything. They can rely on a rumor and a dream and something they heard on the wind in terms of starting the investigation, right? So between these two extremes of I had a dream about it versus actual hard evidence with evidentiary rules and proof beyond a reasonable doubt, right? Between these two extremes, we obviously move along the way. And that changes basically every step of the way. So for example, we talk about probable cause. Probable cause is more than I had a dream about it. It's more than reasonable suspicion, right? So we talked about that, for example. And Nate is absolutely correct. You can use hearsay in most states. You can use hearsay in a search warrant application. You can use it in an indictment. You can use it in a lot of purposes. In fact, frequently you can use hearsay upon hearsay. You can use double hearsay if the hearsay has other indicia that's sufficiently reliable. So yeah, you get away because we don't need as much confidence, right? The reason we exclude hearsay in the first place is because we don't have a lot of confidence in it. Because who's this asshole? Who's saying what? And why isn't he saying it in court, right? Who's this jackass? Right? So the reason we exclude it in the first place is because we don't have a lot of confidence in it. But we don't need a lot of confidence at the start. We don't need that level of confidence, so it's allowed because it matches the level of confidence we need. And now you know. Fun times.
An issue with substance abuse of the parent. I'm concerned with how that impacts the kids. He's clearly asking for a wellness check. He's not asking to raid the house in front of the kids with a bunch of armed police officers.
Well, that may or may not be what he's asking for, but that doesn't matter because, again, it's the nature of the information the police came into, right? And the nature of their concerns, which we talked about before. Like, what is he saying and how and what evidence do they have? And there's like, okay, they decide to go investigate the drug thing. And then they go about investigating that. And if he did not observe it himself, then there would be like, who did I hear it from? Did the police go interview that guy? We've had this discussion, right? Did he see it himself? If so, we're probably done. Did he not see it himself? He heard from a guy. Did we talk to the guy? If so, we're probably done. But the issue is the reliability of the informant. And so, but if the informant gives us information to go talk to a guy, like we can do this in many ways. We can do full 6 degrees of Kevin Bacon, right? A guy leads me to a guy, leads me to a guy, leads me to a guy, who leads me to a guy who tells me about the drugs. It's like, that's fine because then I went and interviewed the guy who told me about the drugs. And as long as he's sufficiently reliable, now I'm there. Now I've moved from like 6 degrees to 1st degree because I did my investigation. And there you go. So fun times.
Ramming the door down. And so I think there's serious Fourth Amendment issues present here because I'm very curious how they got to probable cause because by golly, it ain't in that detention warrant. And then we
By the way, someone looked it up for me in chat as we've been talking. And they said that the Ninth Circuit rule that Barnes alluded to appears to relate to this case called Lanier versus Woodburn, which dealt with a pre-employment drug testing policy, which is not the same as a probation policy or a parole policy or a bond policy. Those are not the same thing. So, yeah. So that doesn't flow. But thank you for the person who looked it up in chat. Assuming that's what Barnes was talking about, he way overextended, and that doesn't surprise me because he tends to do that. He tends to do that sometimes. So, okay.
We still have another one because they're busy violating every constitutional liberty they can figure out there in that small Minnesota county. We have the Sixth Amendment issues. They apparently were on notice at some point early on that he was the counsel for his wife and for the third person that was arrested there. It's one thing is Why are they arresting everybody? It's like they arrest.
Because everyone's in the place where drugs are found. And so everyone has, the question is probable cause. Probable cause is a very low standard. It's like 1 out of 10. I found the people in the place with the drugs. I mean, you know, yeah, it's pretty basic.
Did everybody in the house? You mean if they do some sort of raid at some place, a party or possession, you're not supposed to arrest everybody, but they arrest every adult. So the kids get forced out of the house. That raises its own question. Clearly, they didn't have much evidence on the third person because then they dismissed the charges 2 days later.
That would be the correct thing, right? Because they had probable cause and then it fell apart. So yeah. But yeah, I mean, I don't know whether or not the police typically, I don't know how they deal with a drug den or a drug place. I would not know, but I wouldn't be surprised if the police go into a place where drugs are found and arrest everybody. I wouldn't surprise me. It also would not surprise me if they only arrested specific people, if they had like some sort of knowledge in advance somehow that those people were the people they were looking for, or like other people were guests, if they somehow like knew that. Right. So it's like a dinner party maybe. And so it's obvious those people don't live there and they're just arresting the homeowners, that kind of thing. But yeah, arresting everybody seems like a probably a normal course of action. If I had to bet, when the police are doing a raid of a place where drugs are found, arrest them all and sort it out later. You know, sounds plausible.
So her name is April Imholt. They dismissed her charges?
Mm-hmm. All dismissed, all gone, all finito.
Some people might be hypothesizing that means she's cooperating with the state.
There's always a possibility that that's why they arrested her. But here's the issue. Did they talk to her? If they knew Rekeita was her lawyer, did they talk to her without notice to Rekeita? Because that's what Rekeita reported. He said he had been foreclosed from talking to either his wife, who he was representing, or her, who he was representing.
Now, let me stop you there.
They put him on immediate notice. He says he put them on immediate notice that he was representing them.
I'm not sure that works, incidentally. The client has to ask for it. I don't think the attorney making the representation works either. And so, yeah, the client has to ask for the right to a lawyer. And then the police, all they have to do is stop questioning. They just have to stop questioning. They don't have to provide you the lawyer. They just have to stop asking you questions. So if April didn't ask for a lawyer, then, you know, it doesn't matter, because it's her right. It's her right to a lawyer. It's her Miranda warning. So Nick over here being like, I'm their lawyer. It's like, unless, you know, they say I want a lawyer, I don't think that gets you very far. Plus they're all arrested at the same place. Plus they're arguably facially co-conspirators. Plus they have an obvious manifest conflict of interest. I mean, the conflict of interest is obvious because they were all arrested together. The easiest thing to do is for one of them to point the finger at the other, which inherently is adverse to everyone else. April saying the drugs aren't mine is inherently adverse to Nick, because if they aren't hers, they must be someone else's, and there aren't a lot of other possibilities. Her very denial is adverse to him because it implicates him. Right? And so he can't give free and fair advice to April because the conflict is irreconcilable. So, you know, yeah, there's that. What makes I think she didn't ask for a lawyer? I don't know whether she asked for a lawyer or not. I don't know. I just was pointing out that it's her right. And also the police let her go. So I'm not sure if it matters. You know, and also it only matters if the police were asking her questions, because you only have Miranda if they're asking you questions. Maybe they didn't ask her questions. I don't know. So, you know, I don't know. I was just saying.
So that's Sixth Amendment right to counsel issues. There's also Miranda issues, because they'll said they would have Mirandized everybody. But it's like, did they arrest her solely to scare and terrify her into telling whatever story they wanted her to tell outside the presence of counsel? So they didn't have probable cause for the arrest, didn't have probable cause for her detention. And
her credit cards were found in the master bedroom near the drugs, weren't they? I mean, it's kind of probable cause. I mean, for an arrest. Weren't the credit cards like found right next to the drugs? So like, that's a little suspicious.
And then invaded her Sixth Amendment rights in order to secure whatever favorable testimony they possibly could as payback to Rekeita being a high-profile public critic.
Let me ask you the question before I'm going to read some of these chats because they have some decent questions in there as well. It's one thing to say I want to represent someone and I'm being denied counsel. Can a co-defendant who's an attorney represent another co-defendant?
Oh yes, and I'll give you an example because the government's done this nonsense to me.
Okay, this should be entertaining. All right, so the question is, can a co-defendant represent the other defendant? And Barnes says yes. Okay, one of two things is about to happen. Either Barnes is about to teach me something, or he's going to go way off the reservation. Okay, let's see what you got.
So one of the games the government likes to play, they did it to Gotti when they finally got him, is that they try to find a way to separate out the client from the lawyer. And now I was very public saying, if you're in a situation like Nic's, get independent counsel right away. It's the first call you make. You make sure they're all lined up. You make sure the cops all know. You make sure everybody all knows. That's just tactical advice. Putting that aside, that still doesn't change the constitutional analysis. So absolutely, he can represent them, and they can challenge it at a later point about whether there's a conflict, an unwaivable interest. Yeah. But when the government has done this multiple contexts in my cases, they try to always separate out the defendants. Usually, the defendants are best served with joint defenses, often joint representation. But because
joint representation by an independent lawyer is a different scenario. That's a completely different scenario. One lawyer representing both co-defendants. We're talking about one of the co-defendants themselves being the lawyer who's representing the other one. That's a problem. The problem is because the lawyer is both lawyer and client, and he has a conflict to himself, right? If you have a completely independent lawyer giving advice to two people, as long as their interests are aligned, then, fine. Because their interests are aligned, and he can give advice to them both because he's independent. But if he's also the client, his interests are directly adverse to the other client in this context. Now, I would imagine there are circumstances in which the government could potentially abuse this, I would think. But that doesn't look like the scenario. I mean, it's literally their house. They live together. Did you know that? Did you know that they lived together? Did you know that Nic lived with his wife? Much the same way Juror 1 lived with his wife. Did you know that Nic lived with his wife? It's true. And so, there seems to be some potential issues when it comes to conflicts of interest. So I don't think the scenario quite works, but okay.
That the best way they get people to point fingers at each other, both of them usually go down. That's how that tends to work, particularly in husband and wife situations. But the other aspect is they also, if the lawyer's real effective, they go after the lawyer. So years ago, I had a case in which my client sort of stumbled into a massive Obama scandal. And the scandal was that the Obama administration was using the IRS to enforce Obamacare. And it was the pretext by which the Obama IRS who already had everybody's most private information through the financial records they confess each year on their tax returns, and their other mass gathering of it. Part of why they want the PayPal information and all the rest. It's to put you into the surveillance grid. It's not about making sure they accurately collect tax.
Oh, okay.
But what they did in this context is they were stealing everybody's medical records. They were going around to medical care providers and record keepers especially, and forcing them to turn over all of their medical records. This was information that gave them, I called it J. Edgar Hoover's wet dream of a blackmail file. And they had stolen the medical records.
What do we mean by medical records is the first thing that comes to mind. What exactly do we mean by medical records is the first thing that comes to mind. All right, so this is at a time when the IRS has been charged with the care of Obamacare. This is back when there was the individual mandate, and if you didn't pay it, there was a financial thing, right? And so if the IRS is looking for like records relating to payments, to validate that, then they can look for that. So are we talking about like billing records? Are we talking about like proof of insurance to prove that the insurance was paid for? Are we talking about, that? Or do we mean I want to see the chart? So what exactly do I mean by medical records? So the IRS is going around collecting. What do you mean by medical records?
Of every judge in the state of California, and I'm sure they were doing it across the country, of every Major League Baseball player, of every screenwriter, of every movie director, of every movie actor, of every movie producer. They were stealing all of it. And basically they had blackmailing some of the most powerful people in the world, either in terms of social influence or political influence or legal or economic influence. Because, they knew who had been in for sex addiction rehab treatment, for example, right? What? That kind of thing. He stumbled into it and started to report it. And the IRS decided to put him under microscopic inquiry for criminal tax cases and tried to lock him up for life. And he hired me, and I was the hit. I exposed what they had done on the medical records, started exposing their other misconduct. The prosecutor involved was very politically connected. He was the guy that was picked by the Obama administration to handle fast and furious charges in another jurisdiction. That's how politically ambitious this guy was. But the IRS got very agitated, and his office got very agitated that I was having a lot of success. And so they decided to manufacture a case where they were going to accuse me and my client of being in a conspiracy to assassinate the prosecutor on one of the most ludicrous, asinine.
What?
Absurd charges ever, but their whole goal was to separate me from the lawyer. Say, oh, now you can't represent him anymore, Barnes, because now we got an accusation against you two, and if you don't play ball, Barnes, or be nice, maybe this has a death penalty statute that this carries with it. And my
what?
attitude was, F you. That I'm going to protect my client's constitutional rights and my own. And, let's see how this all works out at the end. In the end, by the way, he didn't serve a single day in federal prison, didn't pay a single fine, but he did recognize the need to get out of the United States, and he's not come back since. And this was a guy who was a deep-hearted American when the whole case started. So this is an old game. They did it to Gotti. They got Gotti talking to his lawyer on tape in a way that they could interpret in a certain way that got a judge to say Gotti could no longer use the lawyer who successfully got him acquitted repeatedly. So this is an old scam of the government, and it's never an excuse, and they know that. So that's right.
It's very frequently an excuse because it represents an inherent and intolerable conflict of interest.
I think all the law tubers out there, I understand people's personal concern for Nic. Everybody wants Nic to do well. Nic has been a stand-up guy for a long time. He's helped a lot of people. By everything I've ever seen, he's a stand-up family man. He's a guy that stood up for Kyle Rittenhouse, was his lead advocate in the court of public opinion, and I'm glad he exposed corruption when he saw it in his local jurisdiction. Everybody wants him to do well. But what LawTube should start to focus on, in my view, is what the heck's going on in that county. This looks like serious, significant constitutional violations as punitive retaliation against someone they don't like.
All right, here's what I'm going to do going forward. I'm not going to be doing any of those things. What I will be doing going forward, as I continue to cover this case, which I assume is going to happen at this point, but what I will be doing is I'm going to try to provide an objective analysis. And to the degree that I have questions or don't know or need to speculate, I will highlight those things so you know that I don't know or I need to know more or I'm speculating. So what I'm going to try to do is keep this as objective as possible, and probably not so much with the deep dive conspiracy theory, not for the least of reasons that even if it were true, I don't know how you would theoretically even go about that. Once you look at the objective lens. So I'm going to go take a pass on that one. Does Barnes have anything more to say about this thing, or is he wrapped up? Let's see.
And we should all be concerned about that because that can happen to any of us who call out corruption or fraud in our government.
I'm going to read through as many of the super chats that relate to Rekeita before we move on to the other subject. Could probable cause have come from seeing Nic with apparent powder on his nose on a live stream? I haven't seen that. I've seen people commenting on that.
There's nothing in there. See, that's what I was like. Maybe they drew some connection. Maybe they used some evidence. Nothing. None of that is in the probable cause affidavit.
By itself, that wouldn't be enough. But if they had other indicia as an additional element, maybe. Because you can't like know what's on his nose. I mean, that could be anything. But if they had other evidence and that was like a piece of the puzzle, then maybe. But not by itself.
For detention.
Yeah, unless it's in the probable cause.
Why would that be in there? Even if that was the basis, the guy included whether the dishes were dirty, right? I mean, you would expect that fact would be in there if it existed.
Barnes does not seem to understand the distinction between the probable cause for the arrest versus the probable cause for the search warrant. These are two completely different things. We only have one of these things. Barnes doesn't seem to understand or appreciate that they are two different things. We need, those are completely independent things, not for least of reasons that they don't both have to happen. They don't both have to happen. Maybe we arrest the guy, but we don't have a search warrant. How? Well, we didn't arrest him in his home would be a great way to start, right? Or we found him in public. He did an offense in front of us, whatever, right? So we could have an arrest, but no search warrant. That's certainly possible. And we could have an arrest warrant without a search warrant. That's possible, right? Just arrest the guy. You know, we have probable cause against the guy. Well, we're going to arrest the guy. Here's an arrest warrant. Go get him. So we have an arrest warrant, no search warrant. So we have probable cause for the arrest. And we can have the other way around, right? We have a search warrant, but no arrest. Because, you know, all we found was lemon pound cake, for example. So these are completely different things. Our probable cause to arrest is completely independent of our probable cause to search. So all we have is the probable cause to arrest. The probable cause of the arrest is superficially sound. The probable cause of the arrest is superficially sound. It looks okay on its face. Obviously, we can challenge it in parts. We've sort of highlighted that, but it's correct on its face. It's facially sound. And if we get the other thing, then we'll analyze that too, and we'll see.
Mm-hmm. Even if it's cleared up, there will be no understanding to stop swatting Nic. His address was given out during the hearing. He looks unwell, though. There was no Glock in Nic's police report. The gun was under the bed, an unloaded Sig Sauer AR. The spent shell was a .22 caliber. No .22 caliber was listed in the police report.
Could a Sig Sauer AR be a .22 caliber? I mean, that would be unusual, but I guess it's hypothetically possible. All right, pressing on.
So the whole base.
There are people who often carry different things in bullet and unused shells.
And Pasha says, if the charges are true, the children get the short end of the stick. If the charges are false, the children get the short end of the stick. I think even if the charges are false, we've witnessed the behavior that should
what the government is capable of. I think there's serious I mean, for example, that judge should have disqualified herself right away. Who signed that search warrant? I mean, why isn't their discretion being exercised by these judges and being careful? I think that, you know, what we're seeing, and maybe it's a good transition, we're seeing courts, whether it's the Amos Miller case and dealing with the state government there, whether it's the illegally imprisoned farmers dealing with the rogue Commonwealth Court judge, whether it's the judges trying to lock somebody up because somebody recorded a proceeding and documented judicial corruption there in the Pennsylvania courts, or right to Trump. What we're seeing is, or in the Rekeita case.
Sorry, go for it. Before we get into Trump,
we have a common theme in all of this, which is out of control judges.
We're going to get to the out of control judges in the Rumble side of things. In vivabarneslaw.locals.com, people should believe Robert. The police, in my experience, never help addicts. They only want to jail them. Nic should choose the no condition.
Would it be a little bit much to suggest that Robert Barnes is a little bit leaning towards more of the conspiracy elements in overall context based on this and other things he said? maybe a little bit of little conspiracy friendly. It's a lot. I will stick by my earlier comment that Robert Barnes has a tendency. I'll stick by where I started this stream, that Robert Barnes has a tendency. Robert Barnes's biggest sin as an educational lawyer, as opposed to a practicing lawyer, but his biggest sin as an educational lawyer is he expresses everything with absolute, complete confidence, no matter how much nuance there is, and quite often, even if it's completely opposite of reality, and he doesn't tell you that. He doesn't tell you, oh, this is my view. I think that this is wrong. But, this is my view, but it's not the law. He just says things like it's the law. He says everything like it's a black letter law certainty, even if it's not compatible with, and sometimes even if it's directly against what the law says. And, yeah, it's a lot. There's a reason, for example, that Attorney Tom is somewhat known for saying it depends, along with other lawyers for saying it depends. There's a lot of nuance in law. There's a lot of things in law, and there's a lot of like, it could be this or it could be this. It depends on this, depends on this. I'm not sure I've ever heard Robert Barnes ever say it depends or any variant there too. He's not a it depends guy. Yeah.
Bail. The subsequent testing is a setup, says NY Renal MD. Nick should have chosen the no condition. Okay, we got that one. And then I'll just get a few left over here in the Rumble to see if we've missed any questions before we give the menu of the evening and move on over to Rumble, because we've been here for a while. Anton's Biltong is delicious. Then we got King of Biltong. Good evening from Anton's Meat and Eat. Free shipping on your Biltong using code VIVA. BiltongUSA.com, AntonUSA.com. Happy birthday, Viva. We have sent you some Carmian red tea. Enjoy. Thank you very much. Okay, Mega Mobas says 1,000% or 100% agree, Barnes. I'm certainly glad, though, that there was some form of intervention. Nick isn't well. However, there was no reason for the level of intervention. I'm very curious to see the warrant. My only issue with Rekeita is that his hypocrisy damaged his credibility, says Pinochet's helicopter tour. Rockahora, the Rekeita case seems fishy as F to begin with. Rackets is literally prescribed the legal version of meth to begin with. I think that
he thinks Nic Rekeita is prescribed Disoxin. I mean, that's a pretty rare script to get. I mean, there's not a lot of people out there with the prescription meth. Does he know that Rackets takes Disoxin? Because that's a pretty unusual script to get a hold of. Damn. Yeah, I mean, damn. Maybe he meant to say Adderall. Maybe he meant to say Adderall, because like, yeah, prescription meth is a hard script to come by. That's a pretty hard script. Yeah. Adderall, which is basically speed, is much more likely. Provigil is none of those things. Provigil is a medication I've taken. Provigil is Schedule 4. It is an anti-narcoleptic, and I've taken it in the past for sleep apnea, and it is definitely none of those things, and it's decidedly not meth. So there's a little bit of a difference between Provigil and Disoxin. I'm wrong. Which one of those things am I wrong about? Which one of those many things am I wrong about? Those two are kind of hard to mix up. Yeah. That's true. Yeah. Meth is not amphetamine. No, you're correct. It's not. It's completely different. You're right. Amphetamine is basically speed. Meth is completely different. You're correct. Yes. You're completely correct. Amphetamine is basically speed. And meth is meth. Yeah. All right, great. Adderall's from the methamphetamine family? I don't think it's from the methamphetamine family. We could look it up, though. You want to check it out? Maybe I'm wrong. I mean, let's find out. It's amphetamine. Yeah, Adderall's amphetamine. It's literally amphetamine. and dextroamphetamine. Yeah, no, it's amphetamine. Yeah, I thought that. Yeah, Adderall is amphetamine. Amphetamine is speed. It's just prescription speed. Yeah, so yeah, I think I got it right. You don't sound like Barnes confident? Like I actually checked? Yeah.
That's an Adderall or something. Why on earth would he have the legal version? Well, I mean, you can think of ways that things can be reconciled or, explained away, but the public display that concerned everybody is still a separate issue. Sadaka says, I spent a lot of shells.
Kurt, you're correct. I can tell you if Disoxin RX is in the picture, all holy hell will come down. I can elaborate more. Adderall's not meth. Yes, I have no particular problem. Renal MD, New York Renal MD. I have no particular problem that if you're writing a script for Disoxin, which is methamphetamine, it's prescription meth. I have no particular problem believing if there's a doctor and you're writing a prescription for prescription meth, someone may have a question. That seems like something that would be likely to occur.
I have a lot of shells lying around because I reload. Spent shell means nothing. Just thinking Rekeita was pretty loud and constantly talking about the corruption at all levels. I wouldn't be surprised to find out that the DOJ was involved in his arrest. Love you guys. Happy birthday, both recently. I think that's it for Rekeita. Okay. What we're going to do, Robert, tell us.
All right. I guess I'll sign off because they're done with that thing. Yeah. All right. Well, we ended with fun. We ended with a fun little pick-me-up. A fun little pick-me-up that wasn't meth-related. So good times. So, yeah, I mean, okay, so the First Amendment doesn't work. The Second Amendment doesn't work. The Fourth Amendment is obvious, but we don't have enough information to critique it. The Eighth Amendment is the unconstitutional bail, which seems possible, but he would need to make a reduction for bail, and he might get a reduction in bail at a later time, assuming he paid bail in the first place. And, yeah. Yeah, Provigil is a totally different kind of drug. Yeah, I know, because yeah. So, good times. Okay. And I've had fun today, and I hope you've had fun. And I did notice a couple people misquoting me and misunderstanding me, which I suppose is to be expected in my previous commentary. For the record, of course, not that I said differently, but in order to clarify, I never said that like the mandatory reporter broke the law, and I just said that my feeling was one of resentment because he hurt my friend, which I acknowledge is kind of a one-dimensional analysis, because you could very reasonably ask the question, well, like, isn't your friend sort of responsible for that? Didn't he bring it on himself, or isn't he in some sense like why did this happen to your friend? Do you want to ask that question? And I'm like, well, my reaction was very one-dimensional. It was a very surface level reaction, which is still my reaction, incidentally. The limited passage of time has not prevented it from being one-dimensional, but I acknowledge it's a one-dimensional analysis, and I acknowledge it's an incomplete analysis. But like, I never said that he did like something legally wrong, and I certainly never said that it would, like, in and of itself prevent the warrant from being valid, right? The question is the reliability of the informant. Purely anonymous informants are illegal. You can't have a purely anonymous informant. You have to have some independent indicia of reliability. It could be based on a person who knows, the person who's personally seen things. It could be that, although much more typically, you would want to combine that with some other additional evidence, but that's possible. So and that's the question, right? So so we're back to where we started, right? What I said, it's like, did the pastor see it himself? If he saw it himself, whatever it is he saw, then it's what he saw, and the police obviously can rely on it. He's a reasonably credible person. He's a pastor in the community, a person of reasonably reliable station, I assume, in his community, right? It's not like it's just not, someone who's reasonably prudent. So it's like, yeah, that's someone you can rely on. If the pastor didn't see it himself, whatever it is, and he's like, I heard it from a guy, then we're back to like, who's the guy? Did we talk to him? Who is he? And how does he know? And so forth and so on. Plus, what other steps did the police take to validate, authenticate, or otherwise buttress their investigation to verify the reality of it. And we won't know any of that until we review the probable cause for the search. But so I think I was misunderstood to some degree. I saw one person who said that I had said that I didn't care about the children, which is decidedly not what I said. I didn't say that even like a little bit. So I did take offense at being misquoted that hard, which was annoying. But yeah. All right, let me read your super chats, and then I'll take a couple like non-super chats, and then I'll wrap up the stream. Let's go back to the top and read all the chats that were here. Blackbird72 has been a member for 40 months. Thank you very much for hitting the join button. Raven254 became an uncivilian. Thank you for hitting that join button. Rubber Toe became an uncivilian. Thank you for hitting the join button. For a mere 99 cents a month, you too can become an uncivilian. It's true. You get to support the channel financially for less than $1 a month. You can't probably even buy a cup of coffee or even a third of a cup of a coffee, but you can support an uncivil for an entire month. And you get behind this, you got the behind the scenes streams and some other cool stuff. You should do that. Not a Banned Account says, love watching Robert Barnes Esquire too. Not a Banned Account says, are you saying the Constitution doesn't matter? Cute. Obvious straw man. I get it. Ping King 554 gives $2 to say, as a scout leader in Colorado, I'm a mandatory reporter. I believe it. 3Mate1 became an uncivilian for hitting the join button. Kim, member for 17 months, says, your assessment of reality is refreshing. I do my best. Janet F has gifted 5 gift memberships. Brian M has become an uncivilian. Thank you, Brian. Charlie Raven has been a member for 11 months. Tony P, longtime mod, hero to the cause, helps me out quite a lot behind the scenes. For $5, it says, here's to Mama Bear of one's mother. I hope your mother will be good. J. Ray became an uncivilian. Rain Maniac gifted 10 gift memberships. Lawyer Ron Coleman joining the crew as an uncivilian, although I think he might have been an uncivilian in hiding all along. We do appreciate him coming out and declaring it. Charlie Lynn gifted 5 gift memberships. New York Renal MD said the child endangerment cards are upcharges. They're correct. They're throwaway charges in their own context. They're a gross misdemeanor. Kids were present at a place where drugs were present. It's a throwaway charge. It's not a thing. It's a throwaway charge, and it's meant for like, it's not really, If they were serious, a protective order would have come, which are standard in domestic case. Correct. Alpha Photographer said, opinion on opening a safe. Well, it depends who and under what circumstances and why. If the police were able to view drugs in plain view in the house, so they saw drugs somewhere in the house in plain view as they were walking around, and they saw like lines of coke or some bullshit, then they can open the safe. If they had a search warrant for the safe in advance, they can open the safe. If the safe was open already, well, they can look in the safe. So without knowing more, it's a little bit hard to know. But yes, we need probable cause to get into the safe. What is our basis for having probable cause? Unclear, because we don't have the search warrant affidavit. Johnny Osprey gifted 10 gift memberships. JSDS Dog Mom gifted 20 gift memberships. MC became an uncivilian. Nate the Lord gifted a membership to say hearsay is fine at grand juries, which it is. Bill Potter says, the charge says he was driving, but no charges for DUI. Well, that doesn't, why he might not have been driving under the influence at the time. I mean, I don't know. He was being detained. He was being detained relative to the search warrant because he wasn't already in the house and they were going to conduct a search. So the detention presumably, ostensibly, was for the purpose of preventing him from going in the house, which they have the right to do because they have a search warrant. If he's already in the house, obviously that's one thing. But if he's not in the house, they can prevent him from going in. So they have a right to secure the scene. So if it was in furtherance of that purpose, then fine. But if it's not DUI, then that's also fine. Grassroots Hegemon for $10 says, if you get arrested in a den, do they take your blood or breathalyze or take urine at the station and try to connect you to the crime at the time? And if so, is that legally usable? I don't know. That's a very fine point of search warrant law that you're pushing me on. So the premise is you are at a place in which drugs are being used. You're at a drug party. You're present there. Okay. The police come in and break everything up. Okay. Can the police arrest you? Assuming the police don't know anything more. Can they arrest you? Probably. Drugs are in use. Can they get a warrant for your blood? I don't know. Good question. Unclear, but you're pushing me and I don't know the answer. And so here's what I'm going to do. I'm going to tell you, I don't know. Instead of saying with absolute confidence, sure, of course they can, or no, of course they can't do that. I'm going to say, I don't know. How about that? That's fun. Shredder S7 says, gotta love Barnes using John Gotti as an antidote. Gnarly Bonesful for $5 Canadian said, whatever I think Barnes might have a point, I have to remind myself of the Gell-Man amnesia effect and wait for someone I trust. Oh, the Gell-Man amnesia effect. Good effect. Yes, the Gell-Man effect. So this is the effect where, like, if you don't know something, you forget that forget that people are idiots. So this is an effect where, like, if you're reading a newspaper, and this has happened to anybody, I'm sure. If you're reading a newspaper or a periodical or basically anything in which you have subject matter expertise, and you read it, and you'll like read it, and you'll be like, this article sucks. They don't know what they're talking about. And then somehow magically, we all collectively, when we turn the page and read the next article that has nothing to do with our knowledge of expertise, we suddenly take it as gospel. We somehow forgot the lesson that when we had expertise, we knew that they didn't know what they're talking about. So maybe they just don't have knowledge of what they're talking about. But somehow, some way, when we go into the next article, we're like, oh, it's in the newspaper, it must be true. So I appreciate that. It's a fun point. Jacob Boardmere for $5 says, Barnes see everything through a constitutional lens. When all you have is a hammer, it's a really small criminal case, not a constitutional one. Yeah, the Constitution is not the foremost problem here, except insofar as we're talking about the affidavit to the warrant, which I suppose is technically a Fourth Amendment issue, but otherwise, not so much. New York Renal MD said I was right about Disoxin. JH became an uncivilian. Cerebral Parasite became an uncivilian. Wise Angel UKC gifted 1 gift membership. J Bob been a member for 30 months. JCF Data for 10 Canadian dollars said, if there were 26.6 grams and 2 adults, how can they both be in possession of the full amount? And what if they're 5 adults? I don't know. That is a very reasonable question. I don't know. But they're presumptively in possession. It's a presumptively in possession because they're in their house and they live together. So they're both presumptively in possession. And then try to figure out whose is whose and how that works. Good question. I don't know if that works for marital property or not. That would be a fun little tidbit if that's true. Can they both own the cocaine? Can it be both their cocaine because they're married? That would be fun. That would be fun if the cocaine is treated as marital property so that they can both have full ownership of the entire amount. A joint ownership of the entirety of the cocaine. I don't know if that's the law, but it would be kind of hilarious. Wise Angel UKC said for $2, did April sing like a canary and get info over? I assume so, yes. All right, so that ends our stream today. Thank you very much for being with me. I hope you enjoyed this. This was fun. I'm going to post a video probably like now-ish. Maybe I'll post it at 4. We got another Karen Reed video coming out today. We got lots of wonderful Karen Reed stuff coming out for those of you who've been present with my editing. And those videos have been doing very well, and I appreciate that. Thank you, JFC Data, for joining the Uncivil Posse. Well, that's even nicer, JFC Data. The Uncivil Posse is our higher membership tier. So I appreciate you joining the higher membership tier, not the 99-cent level, like the normal uncivilians, but you are a full member of the Uncivil Law Posse. Know that I will imagine you with the cowboy hat that you are to be imagined with, because you're a part of the posse. I do appreciate it. And we'll go from there. So are there any further questions before I wrap this up? I'll take a couple questions from chat at the end of this thing and go from there. So if there's any further wrap-up questions. All right, Kayla's charge of knowingly allowing sexual or physical abuse. All right, so I don't know that charge, but now's as good a time as any to look it up. So I'll look it up and see what it actually says. That's a fair question. I haven't looked up her complaint. So let's go see what it says and go from there, if I can find a copy. All right, so give me a second and let me pull it up. Because people have been asking me about it and I haven't ever read it, so now's as good a time as any, right? What happened to the soup videos? Nothing in particular, man. Nothing in particular. We just, things happen and we move on and all the rest of it. Soup time is glorious time for you and me, baby. Soup time is glorious time for you and me, baby. All right. Let's see what this charge actually is. All right. All right. So the charge is, I'll put up on screen. Minnesota, okay, neglect or endangerment of a child / neglect. Okay. On or about May 23rd, 2024 in the county of Kandiyohi, Minnesota, defendant who's a parent, legal guardian, or caretaker endangers the person's health or care by knowingly causing or permitting the child to be present where any person is possessing a controlled substance in violation of law. Well, that sounds pretty banal. That sounds pretty banal. Yeah, that sounds basic. That sounds banal. Yeah, that sounds like a ball. That sounds like a throwaway charge to me. On about May the 23rd, 2023, the defendant who's a parent, legal guardian, endangers the child's person's health by knowingly causing or permitting the child to be present where any person is possessing or controlled substance. That sounds pretty banal. So yeah, I would consider that a throwaway charge. I don't know what I'm missing. I mean, that's her charge. I'm looking right at the document itself. 34 CR 24342. Kayla Rekeita. So, and I'm looking right at. So, yeah, I don't know what you guys are talking about when someone said sexual. There's nothing in it's not there. It's not there in the document. Okay, there's an additional statute referenced. So there's an additional statute referenced in addition to the one that's charged. Oh, okay, hold on. Because it says, okay, so let me make sure I understand this correctly. Because okay. So in this, all right, so for the respect to Kayla, for the drugs, it references the additional statute, which is the penalty. That makes sense. All right, with possession ammo, it references the additional statute, which maybe is a penalty clause. And then with respect to this, it references this knowingly permitting physical or sexual abuse. Okay, so I got to go look that up. So there's a cross-reference. Okay. I wonder why they wrote it that way. Seems like an odd way to write it. Okay, with reference to A2. Okay, I get it. All right, let me look it up real fast. Now, will Minnesota actually let me pull up its statutes today? Because the other day it was not letting me pull up its statutes. Yes, it is. Huzzah. That's nice. All right, so let's see. A2. Oh, this is just the penalty this is just the penalty clause. I think. Yeah. A parent, legal guardian, or caretaker who knowingly permits the continued physical or sexual abuse of a child, is guilty of neglect of a child, and may be sentenced to imprisonment for not more than 364 days. That's A2, right? Yeah. So, I mean, it's a cross-reference, so I'm not exactly sure what that means. I think the idea is simply I think it's just like in an alternative thing. I don't think it means anything. I think it's like just an alternative. That's a good question. But it's a 364 day. It's the exact same penalty. It's exactly the same penalty. It's a gross misdemeanor. So it's exactly the same penalty. So there's that. So yeah. Yeah. So I don't know what's going on there. But fair enough. Knowingly permitting physical abuse. I don't know what evidence they have of that. I don't know what evidence they would have of physical abuse. If there was actual physical abuse, my feelings on the morality of the whole thing would change fairly substantially. Because that would be a much different thing to me. But I'm going to wait to see what's going on that one. My Aaron statement about this effect, Nick. Well, he's to the extent that Aaron is a potential witness, to which he could actually like provide a statement to the police in a formal setting that would implicate Nick in potential behavior, then maybe. Yeah. Is it fair to speculate there's some sort of corroboration for the pastor's report? I think so. Yeah, I think that's probably more likely than not. It's probably it's somewhat unlikely they relied solely on one witness's statement and then just like to the point of searching someone's home. That seems very unlikely. So it's more likely that either they have more than one witness or they have some sort of physical evidence that they somehow created or otherwise saw. Should I watch? Here's a question for the day. Should I watch Aaron's thing last night? Would that like be beneficial to me? I don't know if that would be beneficial to me or not. So I don't know if that makes... Would that be like helpful to me in some way? Yes. Yes, watch it. Not for my mental health. How many grams are in an ounce? I think it's 28. Don't do anything that will give you the sads. He makes some damning accusations that seem credible. No? All right. I'll take my, 28.3. So that's pretty good. That's pretty on point. Yeah, that's pretty on point. Not bad memory. Not bad memory. What's Karen's thing that I'm going to be posting today? That's a good question. I'm not sure. I have to check my list. When the body cam footage is releasing, you'll be airing it. It's not clear to me that we're going to get body cam footage before this case is disposed of. I looked up the relevant statute. I even made an open records request. But if I'm reading the statute correctly, which I'd like to think I am, the body cam records are sealed until the case is finally disposed of. So until the case comes to a resolution. I did file an open records request, but I'm assuming it's going to be denied on that basis. So in terms of when this case is going to be resolved, my expectation would be 6 months to a year, and probably closer to a year minimum. It's going to take a while, unless something like some sort of unless Nick wants like just to be over and comes to some ultra speedy resolution. But I can't imagine that. I can't imagine that like Nick is like super desperate to resolve this thing like right this second. So short of that, or short of something like fatal flaw somewhere, 6 months to a year, probably closer to a year. Do I think Karen's being framed? Well, on some level, I don't care. Because as I've expressed, this is the case of Commonwealth versus Reed, in which the state has the burden of proof, in which the default presumption is that Karen is innocent. The default is she didn't do it. The default is she's not responsible. So that is the starting position. It is the state's obligation to change that, in which they have woefully and catastrophically failed at every possible level. So within the confines of the case of Commonwealth versus Reed, I don't really, strictly speaking, care, because the only question I'm asking within the confines of that case is whether the state has proved its case, to which I laugh in their face a lot. To some degree, it's not incumbent on me to know what's going on. I simply know that the state's story isn't what happened, and I can call it a day. But things look very suspicious towards the police and possibly issues relating to that. Could I be subpoenaed as a character witness? I don't know. If Nick wanted me to, I'd come. That's a long time in the future. I'd come if he wanted me to come. I testify to what I observed. I mean, it's factual testimony about what I observed and what I saw and what I experienced. I'd come. I don't think this thing's going to trial, guys, though. I really don't. I really don't think this thing is going to trial. My expectation is that there will be a resolution, so other than trial. He'll get a plea and some sort of probation? Quite possibly. That'll be clipped and used out of context? What did I say? What did I say? $4.99 says Roxanne wins. Do you know the stats on people who are actually charged and prosecuted for perjury? It's ultra rare. It's extremely rare. I'd come. That's the thing that you want to clip out of context. I'd come. If Nick wants me to come, I'll come. Sure. I mean, I guess. You're really having to reach for this one. But I guess. Sure, knock yourselves out. It'll be a brutal clip. Come on. You guys have better things to do with your time. He said the thing. He said it. Man, even you guys have better things to do with your time. All right, guys, I sign off. You guys have been fun. I'll sign off for now. If you've enjoyed this content, please remember to hit like, comment, subscribe, and all that stuff. And by the way, if you haven't already, just a friendly reminder to check the pinned comment on the which I will now post repeatedly in the chat. If you would like to get notifications of streams and stuff, we're trying to do Instagram notifications. So if you click on that link, I will try to remember to send you notifications so you can learn when we're live and stuff. And that would be great. I've been Uncivil Law. Until later, my friends, I hope all's well for now. Cheers, my friends, and goodbye.